Hello and welcome to the Smart Divorce podcast. I'm very pleased to be joined today by the lovely Rachel Ward from Dickinson Solicitors. I was saying to Rachel earlier, she always looks incredibly glamorous whenever I see her, but she says she doesn't
Lovely.
feel that way. But it's lovely for her to join me. I'm going to get her to introduce herself properly in just a couple of minutes. But today's episode, we're going to be talking about a blog that was released by ourselves earlier on this week, written by Rachel. And Rachel is a survivor of divorce from a narcissist, and she's written a blog talking about her journey. We're going to talk to Rachel today a bit about some of the things that Rachel went through, but also talking about some other options that it's worth considering if you're in the same position or a similar position that Rachel was in. So this is not the same Rachel as the Rachel who
Sounds
wrote
like
the
that.
blog, I should clarify. Um, Rachel, thank you for coming along today. Can you tell us a bit about you, what you do, and your experience of working with people leaving abusive relationships?
So, morning. Hello, everyone. Thank you for giving me the opportunity to come and speak on your podcast today. I'm Rachel Ward. I'm a family solicitor, as you said, working at Hill Dickinson's. I am in the Manchester office, but we have offices in Liverpool, Leeds, Birmingham, London, and also offices abroad. So I have clients all over the country. I started my career in legal aid, so that gave me a lot of exposure to victims of domestic abuse. And even though I've now moved into private practice, I still sort of have a lot of clients that have or are separating from relationships where there has been some sort of domestic abuse. So I have spent a lot of time talking about this to people like you. I recently attended a conference in London. I know that a lot of employers now are keen to learn a little bit more about victims of domestic abuse and people separating from relationships where there's been an element of domestic abuse. I work with individuals who have experienced all forms of abuse. So I know that people often think domestic abuse is physical abuse, but that isn't the case. It's physical, emotional, financial, sexual abuse. Obviously, each of these forms of abuse have lasting scars on people. And I hope now that I have learned enough to have the empathy and knowledge to navigate people through this system. So I've had a little look at this blog that this lady, who's also called Rachel, has prepared. And I can see that she felt that she was in a bit of a broken system, that she found herself in a position where she didn't know where to turn. And I suppose this is really for me and you to show people that there are places to go, for them to find a way of leaving these sort of abusive relationships. So I've briefly looked at the blog, and she does say, first of all, that she has found it difficult, first of all, just making the decision to leave and where to go. And I learned recently that the big banks like Lloyds and TSB have started this new policy where you can go and speak to specialist trained individuals to for them to assist you in leaving now. And I think that that's a big change. And I think it's definitely something that people should be exploring a little bit more, knowing that they have that support from their bank and things like that. They will give them specialist, like non-disclosurable sort codes so their perpetrator doesn't know where they are. They'll help them set up with new PINs, new bank accounts, etc. And I think that's one place that people should start looking straight away.
Absolutely.
Obviously, it's finding a solicitor who's used to high conflict separations. So it isn't always going to be someone like me. It isn't someone who who might not completely understand what is narcissistic personality disorder, but there are people who have a lot of experience with high conflict cases, and it's just gathering your team around you and getting things together practically. So it's speaking to people like you, getting a financial advisor, understanding your finances, because I think a lot of people come to someone like me and think, oh, you can help me emotionally, financially, legally, and we're not a one-stop shop. There are other professionals that are there to assist as well.
Yeah, absolutely. I think it's that, definitely starting with your bank and getting and that support there. I think you need a plan
Mm,
before you leave. You need to make sure that you've got everything, all your ducks in a row. You know before you leave what your plan is, where you're going to go. You need to get your paperwork copied and out of the house,
yeah,
somewhere safe and secure. You need to have all your plan completely in order. And one of the places to start with doing that is the domestic abuse helpline,
yeah.
or even your
Or a
local
charity. There's
abuse
a
service.
charity that's called Hestia that's like a sort of a group after crisis. So there's quite a lot of charities like that. And like you said, the domestic abuse helpline, they can help you with non-molestation applications, occupation orders. But and also just understanding your finances. I always say to people, because people will often speak to me before they're separating, and I say to them, do you have any idea what you can borrow? If you're looking at, purchasing again, you need to just go and speak to people like that as well, and know if you can buy them out of the house, or whether or not you are going to have to move. And that's the one question I always ask at the beginning as well, because some people are desperate to leave the family home, but some people think that that's their one sort of aim, is to keep the family home for the
Yeah.
children and that stability. So I think it's you also setting out your stall, because everyone's different. So you need to guide your solicitor and your team as to what you want your future to look like as well.
Yeah, absolutely. I think if you are looking for someone working as a financial advisor, make sure it's somebody who's not only got experience in working with people going through divorce, but preferably specializes in that area, and also has experience of working with people leaving an abusive relationship, because not everybody has, and you need somebody who understands your situation and is going to, yeah, is going to understand what you're going through and the difficulties that arise from just, I think it's 95% of abusive relationships have some form of financial or economic abuse. That's
Mm.
massive. That's such a huge proportion. So you're probably going to be in a situation where, if you're divorcing a narcissist, they will have, or any abusive relationship, there will be some form of financial abuse, and you need somebody who understands that, and who understands that that means you're not going to have access to money in the same way that other people do. It's fantastic that the banks are stepping up and doing
Mm.
something about it. And there are also there's, and I can't remember the name of the website, but I'll make sure we put it in the show notes. There's a website where you can go and you can get train tickets or bus tickets if you
Yeah.
need to get away urgently. Now, obviously, that situation is you're physically in danger, and then you can go to that and at least get away. If it's going to family, if it's going to friends that are at some distance away, there is that option for you if you don't have access to money. So there are some desperate situations where you can at least access money. And I guess the other thing is emotional support. I know you said before, you're not going to go to your solicitor for emotional support.
They do, but it's very
They
expensive.
do. Yeah, exactly. And same thing, don't come to your financial planner or your financial advisor for emotional support, because whilst we'll do our absolute best to give it, we're not trained in
No.
providing emotional support. We're not therapists. There are divorce coaches out there who can help you through the process at a lower cost than you'll be paying to myself or to a solicitor. There are therapists out there, and many of our clients need both a divorce coach and a therapist
Mm.
to to get them through emotionally, to give them that emotional support, to give them that counselling, because divorce is a really, really tricky thing to go through. It's
Oh,
one of the top
100%.
most stressful things that anybody will go through. And if you're going through that and dealing with abuse as well, and it often continues post separation, you're likely to need that emotional support almost more than you need either of the two of us, don't you?
Yeah, I've started even saying in some of my initial letters, like signposting them to even self-help books and things like that, because not everyone can afford, to go off and have a therapist and a divorce coach and a lawyer and a financial advisor. And so I do sometimes say, there are books now online or, Audible, or for you to go and purchase at Waterstones or, at the bookshops, and just signpost them to them, because there are, support from other places now. And there are, I recently went to another conference, and there's a lady who has written books just on separating from a narcissist, Dr. Sophia McKenna, and her books are excellent, and you can get them on Audible, and they just help you understand also what you're going through and what sort of traits to be looking for, because I think that's the hardest thing, is trying to explain to someone who doesn't understand narcissistic personality disorder how they can come across and how they have manipulated the situation, because they're often charming and really well liked and in good positions, in a good job, well liked by the family and things like that. And but behind closed doors are, very manipulative and have made the person feel really inadequate at home. So, like you said, that's going to then manifest in them probably having a poorly paid job, if a job at all. So that's where there is that, economic abuse, which we touched on earlier. And it's
Yeah,
just really
absolutely.
hard.
And it's one of the first things that Rachel says in her blog is that she was in a system that didn't seem to believe her. And that's the biggest thing, because you're up against somebody who, as you say, comes across as very charming, very likable within society, will probably be well thought of. And
Mm.
so for the person who's been in a relationship with them, they're probably in a position where people are going, no way, that's definitely not them. That they wouldn't behave like that. That doesn't sound like them. So it's massively important they find professionals who believe them, who believe their story, who aren't going to question what they're saying. Because as you say, it's manipulation, it's coercive control, it's them having their own way. And there's, as you say, Supriya's books very clearly define. And as soon as anybody who's been in a relationship with someone with narcissistic personality disorder will pick it up and recognize the playbook, I think Supriya calls it, it's very defined behaviors that work in a systematic pattern every time. Supriya, just as a side note, has been on this podcast, and there is an episode that you can go back and listen to where Supriya talks about this situation. So I think you're absolutely right. Get your team around you, and I know not everybody can afford to have all of the team that would be ideal, but sometimes it's actually lower cost to have all of the people doing the right jobs
Oh,
than
I
it
agree.
to go to the wrong people for them to support you in. Like you say, going to your solicitor for emotional support that's not going to be the best use of your money. So sometimes, although it sounds a lot for people, it's actually comes out to be a lower cost, because you're getting the right people doing the right jobs in the right way. So that
I
that is worth
completely agree.
bearing in mind.
I completely agree. And I think that comes from getting the right legal support as well, because quite often people will try and keep people away from litigation. So people will say, oh, we should be going off to mediation, or we could, we should be sending letters, we should be negotiating. But it's really difficult to negotiate with someone who has narcissistic personality disorder, and they don't have any interest in reaching a fair settlement. They just want to win in their eyes. So they'll delay, they'll be so, I have experienced so many of them, delaying tactics and not providing disclosure, asking for disclosure, and you provide really detailed disclosure, and then you get disclosure back and it just says TBC, TBC, TBC on theirs. And it's so difficult then. And then when you go to court, a lot of people want me to say, oh, you've got to say he's got narcissistic personality disorder. I'm not a professional. I can't diagnose someone. I can recognize their traits, but I don't know what the statistics are, but I imagine there's not that many people who are formally diagnosed with narcissistic personality disorder, because they've got to take themselves for diagnosis, and they are never going to do that. And the courts don't like labels. So I always have to steer the clients into a way of being able to provide the evidence without the labels. And
Yeah.
I think that's the best way. And going to court is really sometimes the only way, because they are trapped within, having time constraints. There's, they're ordered to provide evidence. There's some sort of, not punishment, that's not the right word, but there should be, some sort of, what's the word?
I know exactly what you're trying to say, and I
Refund.
can't think. Repercussions.
Yeah,
There are repercussions, aren't
yeah,
there?
repercussions. Yes, that's the right word. For failure to provide disclosure. And it's a place where we can put the facts to them and to the court for them to sort of, and not be able to sort of squirm out of it, and be able, and once you put the facts in front of them, you do see a very different side to them. And it is often at that point that we are able to then show the judge that this behavior has had some sort of, so it is something that should be considered as a factor when considering the fair sort of settlement.
Absolutely. In your experience, when you've been to court with clients who are in this position, who are divorcing somebody they believe to be a narcissist, have you ever, has it always gone to the final hearing? Can't speak today. Has it always gone to the
Right,
final hearing, or have you ever been in a position where you've been able to reach an agreement earlier than that? Because my experience has been that generally, because there's this I need to win situation, negotiating is incredibly difficult. And even at FDR, which is the middle hearing, they're not willing to give anything at all. There's no negotiating, because there's no give in it's like, I'm not going to give you anything.
Yeah, I think a lot of them do, but not, no, I don't think, I do think that we have quite often been able to negotiate a settlement at FDR. And I think that the reason for that is they know that they're going to be cross-examined. So they know that if we've got enough evidence that we'll run a case of conduct. So they know at that point they'll probably become unstuck. And more often than not, they've probably got someone like a barrister representing them at that point, as well as a solicitor. And because of their personality, they want to look as if they are being reasonable to people who they see as equally as powerful, or, as equally as respectful as them. So quite often that we will be able to reach a settlement at FDR. Not always, like you said, and sometimes victims also want that opportunity to be in court as well, because it's really difficult to establish a conduct case. And I was thinking about this earlier, that I have to prepare whether or not someone's going to say that they want, someone's behaviour to be taken into account very early on in proceedings. So I have to outline that in the first document in the Form E, and then a court has to make a decision really at the first appointment as to whether or not they think that it will reach in a high threshold. And that's only a 35-40 minute court hearing, where really it's used for directions. We have no idea really the full financial picture at that point. So for us to raise that sort of argument at that point is really difficult. And I think that that's probably where Rachel in her blog has found it difficult, where she sort of said that, it's a broken system. People weren't listening to me at certain points of of proceedings. And it is difficult in that sense. And I do think there are some changes that need to be made. And I do think there are changes that are currently being made for us to have as practitioners as well, for us to have a greater understanding of how to run a case of conduct, and where that is really important when there's been an economic abuse. So sometimes, back to your question,
Yeah.
the victims sometimes want to go to a final hearing as well. It isn't always that they're pushed along, but it is a really costly exercise. And that's the difficulty, but the if I don't sometimes make an application straight away because people will want to try and exhaust, you know, a more amicable approach, they'll end up spending double
Yeah.
because they keep trying and then the other person just isn't engaging. So at the moment, I do think that that is the best way half the time. Obviously there's private FDRs and things like that now, so we don't always have to wait for us, for a court hearing in the normal sort of procedure. But I do think that you need someone, a third party. I don't think two solicitors with the best interest of both their clients is enough
Yeah.
in situations like this.
Yeah, not likely to get there. I've got a couple of questions from what you've just said. So you
Yeah.
talked about running a conduct case.
Yeah.
Just explain what running a conduct case means.
Yeah, so we have legislation that we follow. So it's the Matrimonial Causes Act, and we look at factors under Section 25, and in particular, Section 25G, which says that we can look at the conduct of a party when looking at the financial settlement. So we look at that, like I said, early on in the case, and we can complete within the financial information form, the Form E, a paragraph to say that yeah, it is, we can obviously sort of go into it a lot more, and we do. But if someone's picking it up who's a litigant in person, there isn't much space on the form. It looks as if it's not really something to spend much time on, where we can write down reasons why we think that the court should pay particular attention to the conduct of one party. But there is a threshold, and the threshold is that it's inequitable to disregard, and that it's gross and obvious, which is really difficult to define. And like I said, and I think that a lot of practitioners even don't fully understand the sort of that concept, and it is just case law that's sort of balanced upon. So we have the option of running a conduct case, and we can include things like, economic abuse, financial abuse, anything where we think that that's had an impact on that other party's ability to look after themselves financially. But I think that people need to realise though that it isn't for us to make them, it isn't for the financial courts to look at them and find them guilty.
Yeah.
That behaviour, it's just for them to look at whether or not it's something to be considered when we're reaching an agreement on finances. And I think that's the fine balance of the victims understanding that, and also the practitioners also understanding though that even though yes they're not there to find whether or not that person's guilty, if it is something that's important and is going to have a bearing on how that other person has been able to financially look after themselves and contribute and will be able to look after themselves in the future, then it's something that must be included. And it isn't just that we should just be batting them out and saying, oh, well, you should be going to the police about that, or you should be going to get a non-molestation order about that, because I think that quite often, that we can be guilty to sort of say, well, this isn't the right forum for it, finances, but it is.
Well, sometimes it is, and sometimes
it is,
should be on that form.
100%.
I'm gonna just ask you another question. Non-molestation order. You mentioned that a second ago. So there are some orders. So I know Rachel talks in her blog about the broken legal system and about how she didn't feel in a position to fight her ex on an even keel because she didn't have access to money and so on. So I guess two things. What's a non-molestation order? Because there are other things that can be done and put into place before we get to the FDA, FDR, final hearing. what are those things that we should be considering, or that victim survivors could consider with their legal team putting into place at kind of in quite an early stage?
So first of all, there is a non-molestation order which you can apply for. There's no court fee. You can do it as well online through the National Centre of Domestic Abuse, Victim Support Abuse Group. They have special legal professionals who will take you to court. There will be no fee. So if you're eligible to do that, then that's the way that you should approach it. Obviously, there's solicitors as well, like me, who can assist and who've had a lot of experience of making those applications. And they are
What does it?
immediate, yeah, so they are immediate orders where the court will grant it without any notice to the other party to say that they can't come into contact with them, they can't intimidate them, they can't damage property. Then alongside that, there's a consideration as to whether or not they could come within a certain distance of them. And sometimes that lends its hand to us making applications for occupation orders. So they are more difficult to obtain and can be seen as quite draconian because we are somewhat ousting them from the property. But if there's a need to do that, then that's something else that we're there and can assist with. I don't know how much these charities do with the help with occupation orders. I know that they do with the non-molestation orders, but I'm not sure whether or not they have as much experience with occupation orders. But then after that, the other applications that I wanted to discuss was things like the maintenance pending suit application. So, like we said, and I think Rachel says it, that she didn't have the financial support. She didn't have all the financial resources to be able to pay for legal support. So her husband was a high earner. He'd spent £200,000, I think she said, on his legal fees, whereas she was dripping her solicitor, £25 here and there, just to get some sort of help and doing a lot on her own. But we can make applications before or during, obviously, the financial dispute, during the separation, before any final orders are made for financial support.
Yeah.
And what we do is we complete a schedule of outgoings and compare that to their income. And any shortfall we would be saying should be met by the financially stronger party. So we always explore that. The other thing is legal services payment orders. So quite often we apply to court to ask that they pay the weaker financial parties' legal fees. And more often than not, if the financial resources are there, then those applications are successful as long as you've exhausted other methods of payment. So litigation loans, support from family. If there's nothing like that that's available, which quite often there isn't because they might not be named on the family home, or it might be that it's a business that's got all the money in, but they're in rented or there isn't much equity in the property. So sometimes it's quite difficult for people to get litigation loans. There is that option for us to be able to apply for those. And so there is financial support, and we will explore all those options with our clients to make sure that they aren't the weaker party once they separate, that they might have been the weaker party during the marriage or during the relationship, but we'll put them on an equal footing and make sure that they have just as strong of a legal team and advisors and everyone else around them to be able to make informed decisions.
That's brilliant, because I think that's really important. I think a lot of people feel that they need to represent themselves, and that they, as you say, as a litigant in person, so that they're not having the same legal support, and they're up against somebody who's got the best lawyers, well, not necessarily the best, but the most expensive lawyers,
Yeah,
the big kind of London guys who you see on the telly, and and I
it's
think
intimidating.
it is, isn't it? Yeah, absolutely.
Intimidating. And it's really difficult because the people who've left these relationships are, their confidence is probably at their lowest. And to come across like, against someone like that, then they are just going to accept unfair settlements because they haven't got the financial resources to value things either. And it is costly. We can't get away from the fact that it's emotionally exhausting, it's costly, but if you've got the right team around you, we can make it easier, and we can resolve it faster, I think,
Yeah,
if we take
absolutely.
the right
No,
steps.
definitely. In the blog, Rachel talks about the preparation of her first barrister, who she didn't feel was fully up to speed. And she talks about the FDR. For those people who were listening who have never been through the court process, can you just talk a little bit about what the FDR is, and why it's so important that the barristers are up to speed, and how they can make sure that their barristers are up to speed, what should be happening to ensure that their barrister is as fully informed as possible in preparation for the FDR?
Yes, of course. So
That was a lot of questions, sorry.
all right. I can cope, I think. So there is normally three court hearings. There's the first appointment, which I just discussed before, which is more directions. So you go to court, you say, right, okay, well, we've looked at the financial disclosure and we want to raise a questionnaire. We don't agree on the value of the family home. We want someone, a surveyor, to come in and so that, to give a valuation that we both agree on. We've got business. We need to get, an accountant to come in and value that business. So that's that appointment. When you get to FDR, you should have all that information, and it's used as an opportunity to put forward all the evidence without any sort of examination or cross-examination, for the court to give some sort of indication as to what they think a fair settlement would be. So they will look at the value of everything. They will look at potentially things that people have included in their Form E, the questionnaire, and they will say, right, okay, well, we've looked at all the facts and we think that it should be 60% to wife, 40% to husband. And then we can come away from that appointment and we can then negotiate outside, knowing the information from the judge. Now, Rachel goes on to discuss the fact that she says that she found it really difficult, that they hadn't prepared, that they didn't have the right paperwork and things like that, and that she then, I think, used the final hearing for the opportunity to be able to prepare more thoroughly. Now, I would hope if you had a decent solicitor and that solicitor had fully, briefed counsel, that they should have had all the paperwork ready for you to be able to use the FDR like a final hearing. So it's quite unusual and surprising that she found herself, well, I don't know if it's unusual, but in my cases, I don't know, obviously across other sort of when other solicitors have been acting, that you should be able to use that opportunity properly to be able to negotiate a settlement without then having the cost of having a final hearing, because a final hearing will most likely be 2 or 3 days with a barrister who's probably costing £2,000 or £3,000 a day. And so if you can use the FDR as a final hearing, then that's what it's there for.
Yeah. So the responsibility of ensuring that the barrister is fully prepped, does that lie with the solicitor? Are they supposed to make sure that the barrister has all the paperwork and is also fully up to speed on the case and any issues that have been arising in the case?
Yeah, and I think that's why it's sometimes important to get a barrister early, even if your solicitor is going to potentially attend the first appointment, or is generally running the case. I think if you can get your team early so they can fully understand all the facts, rather than your barrister picking up the papers 2 or 3 days before, having a case that's quite similar the day before that, I think that that's a benefit for everyone to get your legal team early around you to fully understand, especially when you're dealing with someone who's leaving someone with narcissistic personality disorder, and explaining to the barrister. And there's a lot of barristers now who are fully equipped to be able to deal with cases like this up and down the country. I've got barristers that I'll refer to in London, Birmingham, and in Manchester, who fully understand how to approach people like this, but they have to know. And quite often, if your solicitor isn't understanding you and doesn't think that you've got enough of a case to run conduct, then it isn't going to be referred to in the papers. It is going to be very basic papers. This, property is worth X, this business is worth Y. They've been married for 20 years and they've got 2 children and no mention
Yeah.
of anything to do with why the relationship broke down and, and potentially the abuse that's continued post separation.
So as a victim to 5, you need to, if you don't feel that your solicitor is briefing your barrister fully, is there anything you can do about that? Or
I think arrange a conference before your hearing.
okay,
We often do them remotely now, so it doesn't have to be at great expense.
yeah,
I think it's important to have that confidence in your legal team, and you're only going to get that by meeting them and discussing things with them, and and being able to explain how you feel and what you think is important.
brilliant, love it. And we talked earlier, and I know this is something that Rachel's talked about, is the belief in the system. Now, you mentioned earlier people that sometimes people want to try and get everything done through mediation. They want to try and just use solicitors. They don't want to apply to the courts because we know that that's a costly process. And I know you talked about it, sometimes it's necessary if you feel that you're in this situation where the other person's messing about,
Mm.
to apply to the court to get things moving. How would you ever try other alternatives up front? And how do you know? How do you get the sense very early on that actually this just needs to go to the courts because the other person's not going to play ball?
I think that I normally can assess it from a response from a first letter. So it doesn't mean that when I say we're automatically applying to court, that I meet the client and I fill out the paperwork on the first day and
Yeah,
I'm off to court the following day. I'll meet the client, I'll understand obviously what they want. And I always follow their instructions. I always say to them, I work for you, because they come to me and they're so intimidated and they think that I'm going to be really bullish and, tell them how that they need to run their cases. But like I said to you, everyone wants different things. So I always say to them, I work for you, and I'll send, and the first letter I always send to them to check, because they know whether or not, that sentence is going to aggravate that person,
yeah,
or that my tone's too nice or my tone's too aggressive. And we'll work together on the initial letter. And so quite often it'll be, a couple of drafts before it's initially sent out. But the response is indicative as to how then I'll run the case. If I have a letter back from a solicitor or from the person and they are just, mudslinging and not really getting anywhere, then I'll then sort of look to alternatives. Mediation isn't appropriate anyway when there's been domestic abuse. So we quite often can bypass that anyway. But we'll decide whether or not there's any point in entering into voluntary disclosure. And sometimes there is, but more often than not, if I enter into voluntary disclosure, then I get a form E back, even though they've asked for financial disclosure, saying TBC, TBC, TBC.
yeah,
So it is just a delaying tactic. So at that point, for definite, if I get something then and they've wanted to push it to that point, I make the application, because then I'm only updating the disclosure. I'm not having to do Form E all over again.
yeah,
I have got the 12 months, and it is going to be that we're making the application. So we've only got to top it up by another 3 months or whatever before we have that direction from the court. So I'm always just conscious of people's costs. And I always say to people when they say, oh, how much is it going to cost? It's really difficult, because I have to say, well, it depends how the other party engages, and it depends on how far we get through the process and what you can agree on and what you can't agree on. But I also say, it's the time that I spend. So you can also be quite savvy, you only send me one email, don't send me 15, which you could copy and paste into one, because it is just time half the time. And I will always update you, if there's something coming in and things like that. So it is also you just having that element of trust, and solicitors, not just collating loads of documents that are completely unnecessary as well. I do need to understand a little bit, so I might ask for a few, WhatsApp messages or emails, but I don't need a year's worth, because again, I'm wasting your time.
yeah, absolutely. You mentioned that you don't feel that mediation is appropriate for for victims, survivors of abuse. And does that count for any mediation? So you wouldn't even engage in something like hybrid mediation?
No, so I was going to say that, and when I did think hybrid mediation, but that's a very new concept,
It is, yeah.
and it is only something that we have only been sort of exploring more recently. We have had one recently at Dickinson, and it was really successful. Because the mediator can hold privileges, so that's the difference. And in it's worked, and we've reached a settlement using hybrid mediation. So I do think that when I said, yeah, it's not a blanket,
Yeah.
it's not appropriate. There are options to explore that I would obviously canvass with any clients at the beginning as
Yeah,
well.
absolutely. No, that's great. And earlier on when we were talking, you mentioned private FDRs, and I think potentially arbitration is also a consideration that you might bring into these cases to potentially bring them to our close earlier on. Obviously, the post-separation abuse and the emotional drain on anybody going through these processes is horrific. And if there's the finances to enable them to do it, would you say that something like a private FDR and arbitration are appropriate? And if so, could you just tell us briefly a little bit more about both those options?
Yeah, so a private FDR is an alternative to the traditional court route. In the context of divorce and financial proceedings, what we'll do is it will be similar to the way that I'd explained previously, an FDR, except that we would have instructed a private judge. So quite often it's a barrister, and they will sit as a private judge and will be able to attend either at chambers, or clients will often come and meet in our offices, and the other party, and will conduct a court hearing in a more private setting, and they will provide what's called a neutral evaluation, and again advise what they think would be a fair settlement, if they were, if it was being held in a proper court environment. So the benefits of that is obviously the flexibility. We can sort of instruct someone quite quickly. And at the moment, we can be waiting for a final hearing for sort of 6, 7, 8 months. So it does allow people to be able to get to this process a lot quicker. But it is obviously, it can be expensive. We're having to pay for a judge. But it does, there's less maybe sort of letters going to and fro, in between. So it can be quite, there's cost considerations, and benefits to doing it both ways. But if people can afford to do it that way, then it definitely reduces the stress. And because obviously the longer it goes on, I think it's like anyone, it's always the unknown that's scary, isn't it? And I think once you've got that knowledge, then you can then make decisions as to whether or not to put forward offers at that point as well, and to potentially reach a settlement. So like court, it's non-binding, the outcome of a private FDR, so you can still go off to final hearing. But I think it's an effective and an efficient way of dealing with things.
And arbitration's similar to a private FDR, isn't it? But equivalent
Yeah.
to a final hearing. But that does give a binding
it does.
decision
Yeah.
at the end of it.
Yeah, that's the difference between arbitration.
Yeah. So again, those things are worth considering if the finances are available and you want to speed things up again.
So it's just a neutral third party who is chosen, by the disputing parties to be able to guide them into reaching a settlement. But like you said, arbitration, the difference is that it can be binding.
Yeah, brilliant. We're coming to the end of our time together, Rachel. That feels like it's absolutely flown. I think we said before we started recording that we think we could probably have talked all day about all the issues that were brought up in the blog by Rachel, but
yes,
wanted to be focusing on some of the things that we think could be done differently to give people a bit of positive news that there are other options available to you, and it doesn't have to go in the way that unfortunately it did for Rachel if you get the right team together.
Yeah.
Is there anything you want to add before we finish up?
No, not really. I think that the first step is obviously the bravest. I think once you've made that decision to leave that party, then you know that you've taken a step to a brighter future. And it isn't easy, but there are people obviously around to support you through this who've spent a lot of time sort of honing their skills to understand and to be able to guide you through this, as best as we can.
Yeah, well said. Absolutely right. And if you do want to get in touch with Rachel, if you are in this position and you need some legal support in leaving or in going through the divorce process, please do get in touch with her. All Rachel's details of how to contact her will be in the show notes below. So please look them up and get in touch with Rachel if you do need some excellent support. If you have found this episode useful, please do like, subscribe, share, give us a lovely 5-star review, because it does help us to get the podcast out to more people and helps us to help more people. So thank you for listening, and we'll see you next time.